Child custody and visitation are often the most contentious issues that must be worked out between the divorcing spouses. It's extremely important to make the right decision and provide the proper accommodations for your child's welfare and overall well-being as they grow up. What is the difference between child custody and visitation? There are two distinct forms of child custody: physical custody and legal custody. Legal custody refers to which parent has the right to make major decisions about the child's life, such as healthcare, schooling, religion, and so on. New York courts typically presume that parents will share joint legal custody and make these decisions together. But in some cases, one parent may be given sole legal custody on a case-by-case basis. Physical custody is separate from legal custody. It refers to the parent who has responsibility for their physical needs, food, shelter, etc., as well as the time each parent is entitled to spend with the child. In joint physical custody, parents share equal time with the child. If the child lives with one parent more than 50% of the time, that parent is typically referred to as the primary custodian or physical custodian. The other parent then has certain parenting time and visitation rights that will be set forth by the court. How is custody determined in New York? Child custody is determined by the court, based on the best interest of the child. A lot of factors can be considered, like the child's preferences, the income and stability of both parents, the safety and home environment each parent can provide, and other such details. If both parents agree on certain custody terms and the court approves, custody can also be determined by this agreement. This is often a faster and simpler way to resolve the issue and decide the custody of the children. Child custody lawyers discuss modification of child custody. Yes. The typical requirement for modifying a custody order is showing a substantial change in circumstances for one parent or the child since the custody agreement was established. In addition, some custody orders can be modified without going back to court if the parties agree to the modification. A substantial change in circumstances is something one or both parents could not anticipate at the time the order was issued. There are many variables as to what would be considered a substantial change in circumstance, which is why it is important to speak with an attorney. NY Child Visitation attorney Martin Moore and his team of child custody lawyers may be able those who need legal advice on the custody of their children. Can a parent with custody relocate? In general, you are not permitted to move away from New York if you have legal or physical custody of a child unless you have the full permission of the non-custodial parent, or obtain permission from the court to do so. You also must have a good reason to relocate. Typically, a change of scenery, or even marrying a new spouse are not compelling reasons. In contrast, employment reasons or a medical reason for relocation may be more compelling causes for relocation. To relocate, you must either obtain consent from the non-custodial parent or file a petition and request a court hearing. In a court hearing, the court will consider your reasons for relocation in the best interest of the child. The court will weigh the benefits and reasons for relocation against the child's relationship with the parent, grandparents, other relatives, school, community, and other relevant factors. The further away you plan to move, the more difficult it can be to win this case. Hat qualifies as an unfit parent? Unfit parents can be defined in multiple ways in New York. An unfit parent could be someone who is struggling with substance abuse, sexual abuse, or physical abuse. They are known to engage in harmful and dangerous behavior around the child. If the parent puts the child into dangerous situations, it could be an indication of unfitness. These are examples of unfit parenting. 1. Poor supervision of the child. 2. Not providing the basic needs of the child. 3. The child is at risk of dangerous situations or safety hazards. 4. The child's other parent is known for hanging out with criminals or gang members. At New York Family Law Group, our team understands how a divorce affects children. Especially with an unfit parent, it can be very complicated to navigate a child custody case. A skilled lawyer may be able to help you understand your rights and responsibilities in a child custody and visitation case. How to prove that a parent is not fit. Even though a parent might have seen or known of unfit behavior, the evidence must be established to bring about legal consequences. A judge must be capable of determining if a parent has been unfit on the basis of evidence in a custody case. Some evidence that may help the court determine the ineligibility of a parent could include: 1. Testimony of witnesses. 2. Video documentation. 3. Physical injuries and mental problems are documented in medical reports. 4. Text messages, voicemails, or emails. 5. Alcohol and drug testing. 6. Criminal records. If you have doubts about whether your child is at risk while with their parent, don't hesitate to inform the court. Your child's safety and well-being are your top priority. After the evidence is collected, paperwork needs to be filed. It is best to have an attorney explain what documentation is. Legally serve the paperwork to the other parent. This will allow them to defend themselves. Seek the help of an experienced child custody attorney in New York. Navigating child custody and visitation laws can be very complicated. It can be overwhelming, especially when you are dealing with a contested divorce. At New York Family Law Group, we have assembled a team of experienced child custody attorneys in New York. With the help of our team, you can protect your rights and the interests of your child. Contact us now at 718-293-1542 to discuss your case and get the legal assistance you need.